Yeah. Now, founder vesting schedule is something that a lot of founders should spend time on, and it surprises a lot of first time founders. So, your own shares in your company are subject to a vesting schedule. Now, the standard structure that we typically have at MV, that 25% vests immediately on day one. Then there is a 1 year cliff, that is no additional vesting until you hit month 12. After the cliff, as it is called, the remaining 75% would vest quarterly over 3 years. That's 12 quarterly installments of 6.25% each. Now, some of you may ask that why does this clause really exist? Now, it protects the investor and frankly your co-founders from someone taking the investment money and walking away. So, let's say if a co-founder who holds 40% leaves at month 18, they've vested 25% upfront plus 2 quarters after the cliff. That's 37.5% of their stake. The remaining 62.5%, that is 25% of the company, can be bought back by the investor at face value, not market value. Right? So this is the benefit of having vesting, so that any co-founder is walking away or leaving for whatever exits, investors still have some rights, and the other remaining co-founders also have rights to ensure that there is enough stake or value at the table left. Okay, this is pretty much standard. Every investor or every institutional investor would expect this, that is information and inspection rights, because they have a right to stay informed about the business since they've invested their money in your company. Now, this typically includes monthly MIS, summary of what is happening, thing in terms of revenue, burn rate, any new clients won, any new clients lost, quarterly financials, P&L, balance sheet, cash flows. They would also want your audited accounts once the CA has signed them. And they typically would also ask for physical inspection rights, that they can visit your office, your manufacturing plant, and inspect any of your books and records and operations whenever needed. Now, this typically never happens. It rarely happens unless you've done some kind of a fraud or things have gone really bad for you. Right? So, don't read this as a burden. And in fact, it would end up building some discipline, some reporting discipline from day one. Now, conditions precedent and subsequent are equally important, because without this, the money is not going to hit your bank account. Right? So, before the money hits, there's typically a checklist of things that must be complete. They are called condition precedents. Now, the standard ones are the due diligence signed off, all IP transferred to the company, ESOP pool created, founders have signed the inter se agreement, that is between co-founders, background checks are cleared, definitive documents, that is your SSA and SHA, are executed. Now, even after the money lands, there are some things that you still need to do. These are called conditions subsequent, typically required to be completed within 60 days. Think of statutory filings, compliance actions that are missing from the due diligence report, milestone reporting systems, right? So all of this also needs to be finished, and failure to finish any of these line items could call for some consequences. Now, three founder obligations that a lot of people underestimate is non-compete, non-solicit, and exclusivity. Now, when you're running a business, by the very structure of it, some of the things may go wrong, and some founders may want to exit, or you may want to shut the company altogether. So that is where three of these clauses will kick in. In non-compete, you cannot start or join a competing business. Over here, typically duration and scope are defined in the shareholders agreement. So try and negotiate the scope narrowly. Similar business should typically be defined very precisely. So don't leave it vague, or it may call for some legal scrutiny later. Now, in non-solicit, you cannot hire away any of the employees if you leave, or poach customers of the company, or pull suppliers for a competing venture. This typically applies during employment and for a period after. Now, the last one is exclusivity, and this is the one that some people tend to miss. Once you sign the term sheet, you cannot approach any other investor for a set period of days. So, there is no investor shopping of sorts, right? And this clause is legally binding, even though rest of the term sheet may not be, right? So, the idea of doing this was that try and understand each of the clauses that you are entering into. Don't be in a rush to raise money or say yes to an investor without understanding the impact of each of these terms, right? Try and model every scenario, run the numbers in multiple case scenarios, best case scenarios, worst case scenarios, understand downside outcomes, especially in case of liquidation preference, vesting cliffs, and what happens when default clauses tend to kick in. Third, Try and negotiate economics and control. A cleaner preference structure matters. And lastly, try and get a good legal counsel. Yes, there is ChatGPT, there is Claude, there is a lot of other legal tech platforms, but a startup lawyer who has seen hundreds and thousands of term sheets for a living is worth every rupee of their fee, right? This is not a place to save money, but rather to optimize for your future liabilities. By the way, you can also check out our website malpaniventures.com. We've uploaded a draft term sheet template and a term sheet explainer under the thesis resources section. You can check it out over here. This is the draft term sheet and this is the term sheet explainer. Hope this is helpful. That's it from our end for this masterclass. I hope you guys understand the term sheet better. We are going to cover SSA and SHA in our next videos. So do follow, like, subscribe, share, and you know the drill. Until next time, peace.